Showing on Law Weekly today, another perspective on Nigeria at 60, a focus on the judiciary. My guest is the former Attorney General of Edo State, Charles Edosonwo, a senior advocate of Nigeria. Also showing on the program, the National Industrial Court holds a special court sitting in Abuja to mark the commencement of its 2020-2021 legal year. The president of the court makes a case for litigants and lawyers to embrace alternative dispute resolution as a way of decongesting the courts. Plus our weekly recap of the trending legal stories in the news. Hello and welcome to the program. I'm Shola Shuyeli. The independence anniversary of the country always provides an opportunity to examine how well the country has fared, especially in critical sectors. On the show today, we bring you another perspective. I began by asking my guest, Charles Uwesunyi Edosonwo SAN, to assess the judiciary in the last 60 years.
On the whole, I would say that of the three branches of government, the judiciary had been the most consistent feature in our body politics, in the sense that with all the upheavals we've had in our constitutional history, independence, republicanism as a 1963 constitution, the push in 1966, coups and counter-coups, the Civil War, the Second Republic. Up till now, the judiciary has always been the steadying arm of our polity. So there must be some credit to be given to the institution for that. You know, there's so much noise about problems in the judiciary. You know, the noise for the small incidents, in my humble view, even though matters of probity are never small when judges are concerned, the institution have done quite well. You know, the voices have continued to be firm on matters of constitutionalism, and they've not, the courts have not balked in, you know, calling out the rules for their obedience. You know, I'm sure you know about certain cases where some gubernatorial candidates from the ruling party lost their seats because they failed to comply with their own rules, their constitutions, and the Constitution of the Federal Republic of Nigeria. And the Supreme Court called them out. And the Rivers State case is there. The Zamfara case is there, you know, and so many other instances. Today, for that firmness, parties are very much conscious about order within their fold.
Democracy.
Yes, within their fold, you know. So, and if you look at this quite well, you have to give credit to the judiciary for ensuring that our democratic practices are being furthered by the firm voices they use in declaring compliance with them. I am one of those who will always invest my faith, or invest his faith rather, in this institution. I don't think it's easy being a judge. For one, I couldn't have been a judge anyway. Not because I do not have the courage or I do not have the learning and all that, but I'm saying this in deference to judges, by way of paying compliments to them that the work they do is not easy. And for how far we've done and soon have done, I will want to give kudos to them.
You touched on party politics, internal democracy, and how the courts have helped. But there are those who say that we're getting to a time when politicians are emerging through the courts rather than through the will of the people. It's the courts who is now determining who wins elections. And that is sad for our polity. There are lawyers who think that.
I disagree with them. I disagree with them. First of all, the courts are there to declare rules. It's a basket of factors. It's a basket of factors. You know, and that is what you call democracy. You know, when rules are transgressed, including electoral rules are transgressed, the courts are there to declare them, to uphold them as part of democracy. And when elections that are supposed to go according to rules have not been so conducted in accordance with rules, the courts won't fold their hands. You know, you can't pick and choose. Each aspect is as important as the other. Even though I will grant that it is always preferred that elections of those who rule us are done in accordance with the will of the people. And even though judges are often referred to as those personages in the branch of government that is only branch of government that is unelected as far as this country is concerned, because there are other parts of the world where judges are elected, you know, on the basis of politics. The roles they perform are indeed public functions, fundamental public functions, constitutional functions, and they are performed on behalf of the people. You know, the only thing that thinkers, I mean, great jurists like Wambueze say is that the judges owe it to the people to explain their decisions to the people.
But talking about electoral reforms, because we've talked about elections and judgments of the courts, what if reforms do you think that we can tinker with to make our elections better?
That's a very wide question you've asked. And you are talking about the whole of Nigeria, the way forward. Just to put in perspective the character of the question you've asked. It's not a subject we'll sit down and talk about for 10, 5, 20, 30 minutes. Political reforms? Oh, there's so many ideas. We should go back to regionalization. We should restructure this country. We should prop up our demography, do a proper census. These figures that are being bandied around that lack credibility, which form the basis for constituencies, which has become the reason why so many parts of this country feel that they've been sidelined and left out unjustly. Redrawing of constituencies. Taking a hard look at our constitution and coming out with what will genuinely work for a country as diverse as Nigeria. Respecting the rights of ethnicities. And forging a formula that while all these are going on, Nigeria will attain technological and industrial freedom so that we can reinforce our infrastructure, take us out of the woods, bring us abreast with those countries that were at par with us in 1960, Singapore, Malaysia, Vietnam, Korea. So if you ask me a question like that, I'll have to do a double take. You have to excuse me for bringing in my own ideas. Even the judiciary itself, we will have to tinker with it in such a way that the courts can do their jobs effectively, have the voices of the courts, loud and clear in constitutional matters, have the voices of the courts, the workings of the courts as well, in commercial matters, effective and expedient in such ways that commercial disputes don't take forever, and as they presently do, discouraging investors from coming to the country. Because, if investors want to bring in their investment into the country and they do not have the assurance that the judicial system is such that will take care of them when there's a problem, because they're in foreign lands, nobody's going to come here. So it's a whole lot of factors we're talking about there. And there's with so many moving parts that we must, as a country, firmly come to the judgment that, look, we better do this now, or we'll remain prostrate for much, much longer. And being the leading country of the black man, I think there's a moral duty for Nigeria to do that right now.
Talking about reforms, because it was one of the issues that the president also talked about during the annual general conference of the NBA. They need to put in time limits with our cases, and he proposed 15 months at the most. Civil cases, criminal cases, 12 months. What can we do? What can the judiciary quickly do to address the issue of time limits and make sure that our cases are fast? Because you also alluded to the fact that investors will not come here if they know that the cases are going to drag. There is no certainty as to when they can come into the justice system and get out. What can we quickly do to address issues of timelines in delay in our justice system?
Okay, now, timelines are not a bad idea. I mean, they are working in political matters now. You know, with the fourth alteration of the Constitution, if a pre-election or electoral case by one day steps out of the time delimited for them, those cases fall into nullity. And people have learned to accept decisions. Nigeria's big problem is accepting decisions. You know, I don't know where we got that character trait from. Nigerians don't like to accept decisions. Today we have a Supreme Court. When we had the Privy Council taking appeals from our Supreme Court, Nigerians were traveling all the way by boat to England to argue their cases for the Privy Council. You know, so if you put a court on top of the Supreme Court today, Nigerians will go there. Some Nigerians misguidedly have sought to take matters from the Supreme Court to the ECOWAS court. You know, I mean, that's clear error. You know, so that's just by way of embellishing the fact that Nigerians find it difficult to accept decisions. So we must learn to accept decisions. And timelines, you know, do that. When your cases fall into abeyance, when your cases run out of time, you know, then there's nothing you can do but accept them. But we cannot also forget the issue of justice. You know, because central to all this, you know, bringing in the factor of time expediency, bringing in the factor of effective dispatch of cases, encouragement of commercial transactions protected by the legal process, political activities protected by a legal process. Justice is at the root of it all. No, we can't ride roughshod over justice, even though pragmatics demand that at times we just have to let things go. So what do? We have to invest technology heavily into our system. Technology needs to come in. You know, I mean, at the time of the COVID times, one would have expected that we should have walked towards virtual hearings. They're happening everywhere in the world.
COVID hasn't completely gone.
Well, I mean, when it came, you remember when it came, there was an uproar about whether or not to adopt virtual hearings.
Some courts did.
Hearing. But that has to happen more. As I speak to you now, because of the confused nature of things, you know, it's difficult to get justices together. Let us take the Court of Appeal, for instance. Difficult to get justices together now and all that. You can't find quorums in some divisions and all that. It's a fact. I'm not saying anything that's not known. Lawyers who have cases where time is running out for them to seek some applications for some leave and all that, they can't have it because there's no quorum in the necessary divisions. If care is not taken, they may just lose their right to appeal, which the Constitution had guaranteed them. Virtual hearings could have helped. If you have one of the justices in Maiduguri, who's home for compassionate reason, one of the justices is in Port Harcourt, who has a reason for being there, one of the justices is in Lagos or anywhere. A virtual hearing is an application. You know, I mean, you dispense with it, and it's done. We have to work towards a situation whereby that will be possible.
Welcome back. Now, as part of efforts to ensure the speedy dispensation of justice, the President of the National Industrial Court, Justice Benedict Kanyip, is advocating the need for litigants and their counsel to explore alternative dispute resolution mechanisms which will facilitate the congestion of the courts. He said this at a special court sitting in Abuja to mark the 2020-2021 legal year. We have some of the highlights from that ceremony up next.
The President of the National Industrial Court, Justice Benedict Kanyip, leading in a procession of judges of the court in activities to mark the commencement of the 2020-2021 legal year of the National Industrial Court. With the judges properly seated, the President of the court begins the proceedings with a call on litigants to embrace alternative dispute resolution.
Section 254(c)(3) of the 1999 Constitution permits us to establish an alternative dispute resolution center within the court premises on matters which jurisdiction is conferred on the court by this Constitution or any act or law. My predecessor set up the center, although it was limited to only mediation. Arbitration is thus not part of the brief. We intend to take a closer look at this to see if arbitration can be added, especially in respect of individual employment/labor disputes. We are of the opinion that individual employment/labor disputes can be arbitrated under the ADR Center of the court. The utilization of the ADR Center is thus one area we intend to take a look at if our policy thrust of shortening trial time is to be achieved. The present COVID-19 pandemic has even made it the more so as measures must be taken to reduce the interface between courts and the users of the court services. We believe that ADR will come in handy here.
The Solicitor General of the Federation appeals to lawyers to cooperate with the court as ministers in the Temple of Justice.
The National Industrial Court of Nigeria is a court created to handle special matters aimed to promote industrial harmony and to streamline labor-industrial relationships and peaceful coexistence among employers and employees of labor. With these mandates, the National Industrial Court has been contributing positively and effectively to the resolution of trade disputes and industrial relation matters in the country. It has also helped in rekindling foreign investors' confidence in the industrial relation stability in Nigeria. In view of this constitutional mandate of the National Industrial Court in dispute resolution, I urge my noble Lord to maintain sanctity and credibility and to continue to ensure that the sacred integrity of the Lordship remain unshaken at all times in order to foster and promote public confidence in all judgment and rulings that emanate from this court.
For the Nigerian Bar Association and the body of senior advocates of Nigeria, the issue of funding remains a critical issue, hampering the independence of the judiciary.
Can we sincerely say that funding of the judiciary at all levels may increase demand of the administration of justice post-COVID-19? The process of appointment of judicial officers at all levels have manifested outright disregard for the principle of separation of powers and independence of the judiciary. In recent times, it has become clear that the Nigerian judiciary and all institutions created under the Constitution to ensure its independence have been manipulated, undermined, controlled, and compromised, all with a view to ascertain superior authority over it.
Achieving full independence from the judiciary in Nigeria will be difficult. The judiciary does not guarantee full financial autonomy under the Constitution. The spectacle of heads of court literary verdict for overheads and general welfare from the President of the Federation or the Governor of the State is an ugly one that highlights the seemingly subservience of the judiciary to the executive arm of government, which it ought to be independent of.
The National Industrial Court of Nigeria is a specialized superior court of record of dispensing social justice in an equitable, impartial, and timely manner, amongst other things. The court has exclusive jurisdiction in civil cases and matters relating to any labor, employment, trade unions, industrial relations, and matters arising from the workplace, the conditions of service, including health, safety, and the welfare of employees. With about 1,486 cases disposed of by the court between October 2019 and June 2020, the new legal year holds a lot of promise, especially of speedy dispensation of justice for litigants and lawyers.
And just before we go, here's a recap of some other legal stories we're tracking.
We'll begin with the report that the trial of the former governor of Ekiti State, Mr. Ayodele Fayose, on an alleged 2.2 billion naira fraud is scheduled to continue on the 19th and 20th of October. The case came up at the Federal High Court in Lagos on Monday, the 5th of October. At the proceedings, the counsel to the Economic and Financial Crimes Commission, Rotimi Jacobs, Senior Advocate of Nigeria, immediately called the seventh prosecution witness to testify. The witness, a banker, Adedamola Otuyalo, who heads the cash in transit services of the now defunct Diamond Bank, told the court how he acted on the instructions of its director, Mr. Premier Oiwo, to move the sum of 1.2 billion naira, which he claims was paid to the former Minister of State for Defense, Musili Obanikoro. The EFCC had alleged that the money eventually moved from Obanikoro to Fayose, who they claimed used it to fund his 2014 governorship campaign in Ekiti State. The former governor, however, denies these claims. On the 19th of October, the EFCC is expected to call its eighth prosecution witness, despite admitting that it was having difficulties bringing witnesses to court because of the recent happenings in the commission. Still in Lagos, another judge of the Federal High Court has ordered the interim freezing of 3 bank accounts belonging to the Speaker of the Lagos State House of Assembly, Mudashiru Obasa. Justice Nicholas Owebo made the order pursuant to a motion ex parte filed by the Economic and Financial Crimes Commission (EFCC), which is investigating the Speaker for offences of conspiracy, diversion of funds, abuse of office, and money laundering. The 3 accounts domiciled in Standard Chartered Bank and the funds in them are to be temporarily frozen pending the conclusion of investigation and possible prosecution of the allegations of fraud made against the Speaker. And from there, we move to the story of the Adamawa North lawmaker, Senator Elisha Abo, who has appealed the judgment delivered by a Federal Capital Territory High Court, Maitama, ordering him to pay 50 million naira as compensation to Osimibriba Womit. Senator Abo was caught on video assaulting Osimibriba at a sex toy shop in Wuse 2, Abuja in 2019. The FCT High Court ordered him to pay 50 million naira and publish an apology to the applicant. The lawmaker has filed a notice of appeal insisting that the facts of the case disclose an alleged tort of simple assault and not torture or inhuman treatment. He anchored his appeal on 3 grounds and argued that the judge erred in law when he dismissed his preliminary objection to the effect that the suit was not recognizable under Section 34 of the 1999 Constitution and the Fundamental Rights Enforcement Procedure. And in Ondo State, the High Court sitting in Akure has sentenced to life imprisonment Prophet Alpha Babatunde, the founder of Sotitobire Miracle Center, over his involvement in the disappearance of Gold Kolawole, a toddler in his church. The 1-year-old went missing on November 10, 2019 during a Sunday service when his mother, Modupe Kolawole, dropped him off at the children's unit of the church. Justice Olusegun Odushola jailed the prophet alongside 6 other defendants. The judge also condemned in strong terms the complicity, compromise and lackadaisical attitude of the Ondo State Police Command after the child went missing, an incident that led to the burning of the church. And we'll round up with a report that the police in Rivers State have rescued the kidnapped female lawyer, Paulette Bisola Ajayi, and an employee of the British High Commission, Paul Niolaku. The duo were kidnapped on Sunday at different parts of Port Harcourt, the state capital, and whisked away to a forest in the state by members of the same gang who demanded ransoms from their families. The Commissioner of Police, Joseph Mukan, said that operatives of the anti-kidnapping unit rescued the victims at the Komoko forest in Eche local government area of the state. Meanwhile, the female lawyer Bisola Ajayi has been recounting her experience since the kidnap. A 25-year-old lawyer who was with her abductors for 4 days said they had planned to kill her after her family was unable to pay the ransom. She, however, commended the Rivers State Governor, the leadership of the Nigerian Bar Association at national and state levels, as well as the Rivers State Police Command, especially the anti-kidnap unit of the command, for their efforts in securing her release.
And here's where we adjourn till next week. Don't forget that you can watch again this episode of the program and past episodes on our YouTube channel. I am Shola Shayeli. Thank you for watching.